Hi, welcome back to Finally Revealed. In this episode, I want to talk a little bit more about contracts and mutuality of understanding and obligation. That is one of the principles of contract formation in the United States, and contracts don't always mean documents in writing. They also mean binding oral contracts. However, as I have talked about in other videos, the statute of frauds requires that certain types of contracts to be enforceable must be in writing, which includes contracts to be performed generally for more than a year, agreements regarding land, real estate, and agreements concerning amounts of money over certain thresholds that are established separately by each state. Written documents control over oral by the very nature of the fact that it is something tangible that is established that you can go back to and read. You don't have to remember, and there's not a he said, she said type of dispute over, what the different parties say happened, or they did agree upon, or they didn't agree upon. It's something that is in writing. So that is always your best evidence, and that's the best way to enter into an agreement because it's written down. Now, when you talk about it being written down, who is writing it makes a difference. When I say writing, I mean not necessarily handwritten, but handwritten does work. Also can be typed or generated in some way that it can be printed out on a tangible piece of paper and then signed by the parties who are entering into the agreement. When you are writing the document, the person who is actually doing the creation of the document and writing it is the one who has the authority over what words are used. Is a good strategy is to make sure that you understand everything you are signing before you sign it. That if you don't understand it, you get information to help you understand it, not from the other party, but from an attorney who can represent your interests. When you sign it, you're agreeing to it. When an agreement is put down onto paper, you should have both sides equally represented for themselves. Write the same contract for two or more parties in completely different ways, depending upon who I am representing. There's a way to write the same provisions, but to leave the benefit for my client versus the other side. When both sides are represented, they each have an attorney looking out for their separate interests. And what you will end up with in the final written document is a negotiated document with give and take for both sides that was presumably fairly entered into. And that's why attorney documents are longer than one that you might write on your own and more complicated than one that you might write on your own, because attorneys have the knowledge, or if not their own knowledge, they have access to the precedent and the case law that defines and shows how the courts have interpreted sections that are in contracts as far as what will be enforceable and what won't be enforceable, what those boundaries are, what words are more powerful, and things like that. So they are putting in their protections for you for when or if something doesn't go as you plan. If both sides make a true agreement intending to follow through, and they can follow through, and they do follow through, and nothing outside gets in the way, no other party gets in the way, no other competition gets in the way, no financial situation changes, and they follow through and they do it, that's great. And that is a perfect example of parties coming together and doing what they intend to do. But there are, like I said, certain situations that can arise that make it not possible to perform. And also there are situations where one party wants to get something and promises to give something, but then they don't really mean it. Maybe they have their, like little kids, you have their fingers crossed behind their back. And so a well-drafted contract will protect you against those eventualities. It's not going to be perfect, but based upon the information that you have at the time and what your best interests are and what your needs are as communicated to your attorney, they can then include that as protection for you in the contract. They can cover that for you or attempt to cover that for you to give you some peace of mind. That also puts the other side on notice that if they do cross the line and if they do think that they're going to pull something over on you, they can see what remedies you have against them if that happens. That helps people follow what they're going to say and make sure that they toe the line. I hope this was clear. It's really important that when you are executing a written document, you understand the words. You understand what this means. You understand your time frames, your rights, your remedies, and it is really beneficial for you to get advice. The bigger the transaction is, or the more important it is to you, the more important it is for you to get outside help before you enter into that agreement. I hope this was helpful to you. If it was, give me a thumbs up. Leave any comments or questions below. Share this with someone who it might benefit. Subscribe to see our other videos, and come back and see me next time. Thanks for watching.